Good morning. Good morning. I'm Michael Reynolds, co-chair along with Alon Warman of the Symposium here today, and welcome to the second day of panels and debate. This panel will be the second panel of the conference on Congress versus the agencies. And I have the distinct pleasure of introducing the moderator, Judge Lois Haight. Judge Haight has been a Superior Court judge in Contra Costa County for 17 years. A former Assistant Attorney General of the United States, Judge Haight has committed her life to the protection of children and victims of crime. She is a fourth-generation Californian and began her law career in private practice and then as a Deputy District Attorney in Alameda County, California. She has held numerous positions nationally: Chairman of the President's Task Force on Victims of Crime, the White House Conference for a Drug-Free America, and the U.S. Attorney General's Task Force on Family Violence, and the President's Child Safety Partnership. Judge Haight has also served on numerous national and state boards and commissions, including USO International, the Federalist Society of Hastings College and the Law, and the National Organization of Victims Assistance. She served as a United States delegate to 4 United Nations conferences on the status of women, victims of crime, drugs and terrorism, and crime prevention and treatments of offenders. She was the President's national correspondent to the United Nations on crime for 7 years. Judge Haight has also been a guest speaker nationwide and a lecturer at many colleges and universities and law schools, including Stanford, and she has won too many awards and commendations to name. Ladies and gentlemen, I have the pleasure of introducing Judge Haight to take it off.
Okay. Thank you. I wish I didn't sound quite so old when you read all that. I thought it was just going to be a two-liner. I want to thank you all for coming today and thank the Federalist Society for making this possible, bringing this distinguished panels together to our law schools throughout the nation is a great benefit to all of us. And I really thank the Federalist Society for doing this. We have a very meaty panel today. Our title is, I want to mention every word: Congress versus the agencies, balancing checks and efficiency, gridlock, organized interests, and regulatory capture. Not much to discuss here. Okay, as an overview, let me state that each panelist will have approximately 10 to 12 minutes for their presentations. Then we'll have approximately 15 minutes or so for rebuttal between the panelists. And then we will take at least up to 40 minutes of questions from the audience. Our distinguished panelists are C. Boyden Gray of Washington, D.C., former White House Counsel for President George Bush in 1989 to 1993, where he worked on many, many things, but among them important areas such as clean air issues, energy policy, clean fuels, and market incentives to achieving environmental goals. He also was former ambassador to the European Union and special envoy for European affairs. That's approximately from 2006 to 2009. He also was counsel to the Presidential Task Force on Regulatory Relief in President Reagan's area, and actually he worked very hard in that administration in many roles. He obviously has a broad experience in our areas of discussion today, and we are very honored to have him starting off with our panel today. Our next panelist is Professor Lisa Heinzerling, Professor of Law at Georgetown University. Having clerked for Judge Richard Posner of the U.S. Court of Appeals, 7th Circuit, and Justice William Brennan of the Supreme Court, she has practiced environmental law in the Massachusetts Attorney General's office. And while at Georgetown, she continues litigation in environmental law. Her most recent experience is in the EPA, and she has received accolades from her environmental law professors and peers. She's author of several books, one entitled Priceless: On Knowing the Price of Everything and the Value of Nothing. And that certainly piques our interest and makes her a very valuable panelist. Michael McConnell, Judge Michael McConnell, is also a professor. I'm sorry, you're always a judge to me, Judge McConnell, is a professor and director of the Constitutional Law Center at Stanford Law School, and as well as a senior fellow at the Hoover Institute. I know he's well known to most of you as a leading authority on freedom of speech and religion and the relation of individual rights to government structure. He is a former judge of the U.S. Court of Appeals for the 10th Circuit and has argued 13 cases in the U.S. Supreme Court. He has an incredibly distinguished background for our panel today, and I know that when I mentioned to several colleagues that he was on our panel today, they were in awe. Our final panelist is David Freeman. He is a professor at Stanford and has a varied background in civil rights, administrative law, employment law, and constitutional federalism. He clerked for Judge Wood of the U.S. Court of Appeals, 7th Circuit, and was a John Olin Fellow in Law, Economics, and Public Policy at Yale Law School. He has practiced law and represented clients before the Supreme Court. But what I found most endearing, and I know you all have summaries of the bios in your pamphlets today, is that he taught high school and coached football. Now, having 4 athletic grandsons, I don't know how you did it and kept your sanity. So these are our very distinguished panels, and for our opening presentation, we'll start with the Honorable C. Boyden Gray.
Thank you very much. It's a real honor to be here, and I'm grateful for the opportunity. Judge, you did leave out one title that I had. I was, as you say, special envoy to the European Union for Energy Affairs. On my last night in Brussels, when I was packing up and therefore couldn't do it, I was invited to a dinner by the Commanding General of the European Defense Force. Now, you may ask yourself, European Defense Force? There really isn't a European Defense Force. But he commanded a staff and a chef and a house, and kindly sent me the guest list to entice me to come, which I couldn't do, as I say. And I was listed as C. Boyden Gray, U.S. Special Convoy. My general thesis is that there has been an abdication of sorts by Congress, too much delegation with too little guidance and too little oversight, with or without waivers, and that this has led to enormous uncertainty in the business community, which in turn has deterred investment, is deterring investment, and that in turn is a drag on our economic growth, our future economic growth. And it hasn't really hit the Silicon Valley yet, although it's beginning to with the privacy regulations. This area has been sort of spared because it takes a while for the regulators and the Congress to catch up to the fast-moving events out here, but they're catching up, and you'll probably hear a lot more about this later. I have sort of 2 assumptions that I grew up with, and so I'm old-fashioned, maybe a little too old to be on this panel. I don't believe there's agency authority or agency agenda without a legislative delegation to start with, and so therefore don't think it's an either-or proposition. I mean, I know practically it often turns out to be, well, we go to Congress or we go to the agency, but I feel as though there is a distinction, and I think there has been gridlock. It's been on the spending side, but not on the regulatory side. Sometimes I wish it were the other way around. We can't seem to get a handle on our long-term spending, but boy, have we had fun with regulations. Now, you heard from Professor Barron last night about the new sort of inverted delegation, and I'm struggling with that because I can see some examples of it, but I think there are more examples of what I was talking about, which is over-delegation with no detail and no accountability. And I'll just give you, or asserted delegation by the agency with no accountability. And I'll just give 2 or 3 examples. Dodd-Frank, it's a complex bill. There is a lot of pages, 2,000 pages. That doesn't necessarily mean there's all that much guidance. Limiting my remarks here just to the Resolution Authority and the Consumer Bureau, which is quite well known now, I think, publicly. There is very little guidance as to how these 2 operations should work. There is no standard for the Consumer Bureau to follow, and for both agencies, FDIC, Treasury, for the resolution and for the Consumer Bureau. The courts are basically cut out of any review. Congress is cut out because there's internal funding, one from the Fed, one from an internal tax assessment for the resolution authority. So the Congress does not have any oversight authority, no ability to constrain the budget. Actually, Title X purports to prohibit the appropriations committees from reviewing the budget of the agency. Now, I don't really see the Sergeant at Arms arresting the chairman of the Appropriations Committee in the House or Senate if they were to hold a hearing, but that's what the legislation actually sort of says. Obamacare, we've heard a lot about that and a lot about the waivers, and I know that's part of Obamacare, but I view the mandate and the IPAB, you heard a little bit about that last night, the Independent Payments Advisory Board, as really being the key parts of what have long-term implications, especially for me at my age. And I look at those, and there's, Congress can't do anything about it, really, unless they get a two-thirds vote, I think, so the majority anyway. The courts are cut out of any kind of review, and it's pretty open-ended and concentrated with no separation of powers kind of checks. Sarbanes-Oxley, again, has led to, probably more than anything else, to this regulatory uncertainty, which has leading the way to cause a dramatic reduction in the number of IPOs that we have seen in this country. Has that yet affected this part of the country? Not yet, but soon, perhaps. It is after its post-IPO growth where the jobs come from small companies, and if you cut the IPOs out and these companies go and their exit strategy is only to merge with a much bigger company, the opportunities for growth are substantially reduced, and there's some very disturbing data on that front. For some statutes, the delegation has been asserted. Lisa Heinzerling and I had breakfast this morning talking a little bit about this, and of course in preparation for this panel, EPA has asserted vast authority over greenhouse gases. There is no detail about this in the Clean Air Act because no one really thought about it when it was enacted and amended. And every time I run into Congressman Dingell, he's always Mr. Chairman to me, even if he's in the minority, and he says to me, young man, he still calls me young man, young man, we didn't cover climate change in 1990, did we? We did not. And I said, no, sir, we did not. But that doesn't seem to have mattered a great deal, and maybe it shouldn't. I'm not going to opine on that. But there is a great deal of authority being asserted. And again, maybe this is a form of waiver. In order to make it work, the agency is waiving a lot of stuff in the statute, converting thresholds of 100 and 250 tons per year into thresholds of 75,000 and 100,000 tons per year as a starting point anyway. That's an interesting form of, maybe that's a waiver, I don't know. But what I see is, with respect to what Professor Barron said, is not this inverted delegation. What I see is a lot of delegation with no detail and no waiver, and then a lot of asserted delegation with no detail and a lot of waiver. If you take what EPA has done to kind of twist the statute to work to regulate greenhouse gases. So I think there can be a reconciliation of all this, but again, my starting point is that there is too little accountability and too much agency power. You heard from Professor Epstein last night about how what you don't see often is chilling effect on exerting appellate rights, and to me this is really at the heart of it, is proof of, or illustration, maybe not proof, illustration of the enormous amount of authority that's been reposited in the executive branch and in the legislative too. I mean, it's not obviously just one or the other. But in Dodd-Frank, there are a lot of, I can assure you, financial institutions throughout this country who are terrified of it and who would do anything to have it challenged on the grounds that I've suggested, that with no judicial review, no congressional review, no White House review. No, the Consumer Bureau is housed in the Fed, which pays for it, but is prohibited from interfering with it. And the White House can't do anything because it's an independent agency with a 5-year term. I think it would be subject to a pretty robust challenge, but people are terrified of being identified with such an effort, and so finding private plaintiffs has not been easy. And this is scary to me when you're scared out of exercising your appellate rights. There's a very long story in connection with climate change. It's not just climate change. It has to do with corporate average fuel economy, some reference to that last night, competing statutory regimes over who has the right to control the efficiency of automobiles. The long-standing delegation has been to the Department of Transportation with the principal purpose of reducing imports, which actually has worked. We are importing a whole lot less now than we were just 5 years ago. Reducing imports, part of that actually has been the increased blending of ethanol, which is disparaged as the cause of everything bad in our country. If we could only get rid of ethanol, according to some, we could balance the budget, get rid of our debt. Ethanol is even blamed for the Arab Spring. I can assure you it's not all that bad. But it has helped reduce our imports. But the assertion by EPA, under Massachusetts v. EPA, the Supreme Court case which said that carbon dioxide is a pollutant, not masterminded, but really created in many ways by Lisa Heinzerling, and I think it's one of the great legal achievements of my generation, what she did. Not that I agree with all of it, but it certainly is something to admire. As part of the deal to understand, to work out the relationship between this state, California, which has its separate Clean Air Act regime, California's relationship to Detroit, to Washington, D.C., there was a grand bargain. I won't bore you with the details, but there was a grand bargain, and part of the grand bargain was that the automobile companies would not challenge whatever came out of the rulemaking process, that the automobile companies would not challenge it in court. And that's a pretty unusual deal. Now, I'm not sure it's enforceable. If an automobile company tried to challenge it in court, they could probably succeed in doing so, but the price they would pay, that we don't know. So it is this regulatory intimidation which is so different now than it was when I first started work in the government, which was back in your husband's time, working with John.
We're the same age, thank you.
Yeah, I hate to admit it. One final word about capture. We used to say, when I was working in the counsel's office, that, it's easy to run a congressman, much harder to run a subcommittee, very difficult to get a whole committee, and impossible to get the White House. But still, I think that given the turnover of Congress and given the competing considerations and the fact that a lot of congressmen do actually go home and bureaucrats tend to stay in Washington, that the problem of capture by the regulated interests is a bigger problem with the agencies than it is with Congress. That's not to say that Congress acquits itself very well. You heard this last night. But I do think that the problem of agency capture is real. It demands more congressional oversight. The courts have got to be very, very vigilant about this. The D.C. Circuit's very good at making sure there's a level procedural playing field. And that is one of the key roles that the D.C. Circuit plays, to make sure that favoritism doesn't creep in procedurally to the resolution of these conflicts, and that goes back to the discussion of the rule of law. But I will stop there, again, with my feeling that we have too much unaccountable delegation, not too little.
Thank you, Mr. Gray. Perfect timing, by the way. Perfect. Professor Heinzerling.
Thank you so much. Thank you to the Federalist Society for having me here. Congratulations to the organizers of this conference for focusing on agencies, bureaucracy, administrative law. These are extremely important subjects, and I am very happy that you're focusing on them here. Having said thank you and congratulations, I'm going to be just maybe slightly not ungrateful, but I'm going to suggest that the title of the conference is mistaken, and indeed its premise is incorrect. The title of the conference is Bureaucracy Unbound, of course, and I would suggest that a more appropriate title, more in keeping with the actual facts of the matter, would be Bureaucracy Bound. That bureaucracies, agencies are not, in fact, free, as the title and some of the questions posed to panelists suggest, are not free to roam at will and impose their own view of the public good, but in fact are constrained on all sides by other institutions of government. I'm going to focus on the Environmental Protection Agency. I spent 2 years there in this administration, and so got to see firsthand how agency officials and civil servants understand their role, and I can tell you it's very much not one in which they feel unbound. I think this will be a nice counterpoint to Boyden's comments that he just made. I want to say, first of all, I don't think there's any reason to believe that the Environmental Protection Agency is aberrational. In fact, in many cases, and indeed in the comments you've already heard, many times EPA is used as Exhibit A in examples of agencies that have run amok and have too much authority. In reality, as I've suggested already, EPA is tightly constrained by Congress, constrained by the White House and the broader administration, and constrained by the courts. So much so that one must wonder, I wonder, whose interests it serves so to constrain an agency charged with protecting the public health and welfare of all of us. So let me start with constraints from Congress. There are constraints by law. The statutes that Congress has passed to charge EPA with protecting health and the environment have only grown more prescriptive over time. That is widely regarded as the approach that Congress takes. Starts broad and gets more and more narrow. Let me give you an example, even that Boyden already mentioned, the air toxics program, which has been the subject of a lot of discussion and controversy lately, especially the toxics rule that applies to utility power plants. This provision started in the statute in 1970 as protect the public health with an ample margin of safety and regulate hazardous air pollutants to protect the public health in that fashion. It has become more and more prescriptive. To this point, there are deadlines for setting standards, deadlines for compliance, rules about how many sources should be controlled, rules about exactly which air pollutants to control, rules about how strict the technology requirements must be. They're extremely prescriptive, not at all vague. And this is just one example. This has been the tendency, I think, as I say, in modern environmental law, has been to get more rather than less prescriptive. So there's the first constraint from Congress, the most obvious one in the statutes themselves. A second constraint from Congress is less obvious, but I think quite well known, which is oversight. In this Congress alone, through the end of February of this year, EPA witnesses have been called to testify in front of Congress 65 times. Administrator Lisa Jackson herself has testified 13 times in front of Congress. These hearings have an impact. It may feel from the outside like they're pro forma, that they're a kind of show, but I can tell you that administrators and other officials within the Environmental Protection Agency take them seriously and are affected by them. The last constraint from Congress that I'll mention is budget, and this is another famous one. One always wonders whether one's budget will be cut, and indeed EPA's budget, along with many other agencies, has been going down in the last couple of years. There are also always the possibility of riders that will reach out and tell the agency not to do a particular thing, not to spend money on a particular thing. There's always that chance. EPA is always aware of that chance, so that it feels real constraints in what it does based on congressional laws, based on oversight, based on budgeting. Based also, I'll say, based on other kinds of riders. One is always wondering whether there will be a bill that will have attached to it provisions saying do not implement this particular this particular statutory provision or this particular rule. Let me give you another statistic. In 2011, the House of Representatives averaged more than one anti-environmental vote for every day the House was in session. Again, this may seem like it doesn't have an effect. It does on the agency. Second constraint comes from the President and the broader administration, and here I'm making an assumption that bureaucracy in the title of this conference is to be distinguished from the executive, from the President. That is, the bureaucracy has some special character quite apart from the White House and the President. And so here I'll say that the bureaucracy, in that understanding, the agencies and their civil servant staffs are very constrained by the President and the larger administration. As you may know, all major rules go to the White House, specifically the Office of Management and Budget, for review. Major in this case means if OMB wants to see it, it's major. 27 out of 28 environmental rules now at OMB for review are not economically significant. They do not pass the $100 million threshold that defines a major rule. Many of them are tiny rules costing $5, $6 million a year, but they go to the White House for review. And the White House in this administration, as in previous administrations, feels perfectly comfortable letting rules stay there and dying there. So if you look at the Office of Management and Budget's website to see the constraints on agencies, I invite you to look and see the number of actions that are there, have been there, I'm thinking in particular EPA again, many of them for over a year. One in particular has been there for almost 2 years. That rule is never coming back. It's never coming back. So that the White House issues very tight control or has very tight control over the agency's regulatory agenda, to the point where the Washington Post pointed out the other day that the White House is now telling EPA simply not to send some rules to it for review. Last, on courts. There's a lot made, and rightly so, of the deference that courts afford to agencies' statutory interpretations through Chevron and the deference to policy judgments through a variety of administrative law doctrines. A couple of points there. One, on Chevron, a tremendous amount of work is done, as you may know, through Chevron's so-called Step 1. If EPA is going to lose on a statutory question, it loses at Step 1. Courts seem sometimes to work very hard to find what seems to be quite not plain language, plain, and to rule against the agency. So that is quite a tight constraint, in my view, on agency behavior. In addition, when it comes to policy judgments and scientific judgments, indeed, the rhetoric here from the courts is one of restraint and deference, but in fact, what you see is a fine-tooth comb going through the agency's documentation and explanation for its rules, to the point where now, at the agency level, this has such an effect that rules can take years, many 5, 10, 15 years to get through a process before they're enacted. I heard Cass Sunstein speak the other day. He is the administrator of the office within OMB that reviews rules when they go to the White House for review. And he noted with some pride that that the agencies now must issue an executive summary for their rules, telling what the purpose is, telling exactly what they do, saying their legal basis, and so forth. And I could not help but be struck how much that sounded like the Administrative Procedure Act's requirements for rules. A concise general statement of basis and purpose. That's all that statute requires for an agency's final rule. And yet we've come to a point where the agency explanation is so grossly inflated in response to judicial requirements that we need an executive summary that, again, looks very much like the original APA understanding of what the agency was to do. And so I would suggest, in closing, I would suggest it may be possible when there seem to be suggestions on both sides of the philosophical divide, suggestions that perhaps administrative state has become too constrained by procedural requirements, that it may be productive to think about whether to revisit some of those constraints. Judge Kavanaugh himself, in opinions, has suggested as much. So in any event, Thank you very much, and I look forward to comments and questions.
Thank you, Professor. Very good. Judge McConnell?
I'm going to speak from here because I have some slides to show. That was, first of all, thank you, Judge Haight, for the introduction, and thank you to the Federalist Society for organizing. And as one of the Stanford representatives here, I'd like to join Dean Kramer from last evening in welcoming all of you to sunny Palo Alto. And we're very pleased and proud to be hosting this conference. And I'm going to be speaking on the subject of the pathologies of the modern regulatory state. Now, I was feeling fairly depressed after last night, and then hearing Boyden, I have to say that Lisa cheered me up a little bit with that bright and sunny account of how maybe the bureaucracy is a little bit more bound than it sometimes appears to be. But I think I may be returning us to the gloom. And in particular, what I want to talk about is the way in which is not Congress versus the agencies, but the way in which Congress and the agencies together have created some serious, I think, pathologies that run counter to the fundamental democratic structure of our system. I want to stress here that I'm not speaking from a libertarian point of view. I'm going to assume that we are looking at a regulatory state with very broad powers, that we are not going to return to a Lockean watchman state. I assume that there's going to be large-scale regulation of economic activity. It seems to me that we need to talk not so much about the extent of regulation, although that is, of course, important, but we need to talk more about the mode of regulation, the way in which it is done, because that affects the consequences for the economy and for democracy almost as much, maybe even more in some respects, than the pure extent of the regulation. And I refer here to the dual phenomenon of the vast, perplexing, incomprehensible laws enacted by Congress, coupled with extraordinarily broad administrative discretion as to individual cases. Now, note that in some cases, long, detailed, prescriptive legislation does not create the second problem. If it is in fact prescriptive, rule-based, statutory rules, sometimes, as Lisa has said, that can constrain discretion. But all too often, we have the worst of both worlds. That is to say, extremely perplexing, complicated legislation that does not, in fact, constrain, that that at the heart of it simply delegates broad discretion to the agencies, not just to create rules, which I think is important, which is good, but actually to decide case by case on an individual basis how various persons and businesses are going to be treated. The result of this is an erosion of the rule of law. Now, by the rule of law, I mean, I'm struck by the panel last night. There was some disagreement among the panel, and so I want to make clear what I mean when I speak of the rule of law, because I'm talking about the importance of the application of settled rules to all cases on an equal and impartial basis. So the values of the rule of law are generality, impartiality, and predictability. That's what I'm talking about with respect to the rule of law. And when you have massive, complicated, perplexing, case-by-case decision-making, it undermines, I would suggest, democratic accountability. It creates opportunities for corruption and inequality, and it has deleterious impacts upon the economy and upon prosperity. Now, none of this is new. and I'm going to organize my talk around some comments made by one of our favorite founders. His picture is on the Federalist Society tie, our friend Jimmy Madison, and in particular in an underappreciated one of the Federalist essays, namely Federalist number 62. In this, Madison has warned against the very pathologies of the modern regulatory state that I'm going to be talking about this morning, beginning with the problem of democratic accountability, where Madison wrote, "It will be of little avail to the people that the laws are made by men of their own choice if the laws be so voluminous that they cannot be read or so incoherent that they cannot be understood." How on earth did Jimmy Madison get up to 2012 and see what's going on in Congress today? How are we doing by this measure? Well, when the Patriot Act was passed under the last administration, it logged in at 131 pages, and many of us thought that that was rather long. It seemed monstrously long at the time. But then when the cap-and-trade legislation was introduced and passed by the House of Representatives, it was 1,428 pages. Dodd-Frank in the House, 1,616 pages. The Senate version goes up to 1,705. The Affordable Care Act, House version, over 2,000 pages. The Senate brought it down to roughly 906 pages. Now, the problem with this is twofold. One is that the people cannot possibly monitor the Democratic representation in Congress when what they're voting on is so vast and indecipherable. I really applauded then candidate Barack Obama's promise when he was running for president that he would urge that all laws be placed on the internet for at least 3 days for public examination before they would be voted on by Congress. A great idea. 3 days is actually pretty short if you're looking at over 2,000 pages, but 3 days is better than what we actually got in Congress, because very frequently these bills now are drawn up by lobbyists behind closed doors and then presented by the leadership on the floor of the House and voted on with very little time for public scrutiny or public deliberation. This harms the very Republican foundations of the nation. But not only does the public not have a chance to read and understand the bill, it became very clear that not even members of Congress were reading and understanding the bill. I'll come back to that. So, chairman of the Senate Finance Committee, Max Baucus, said, "I don't think you want me to waste my time to read every page of the health care bill. You know why? It's statutory language. We hire experts." I thought we were electing Democratic representatives. Now, by comparison, complex legislation of the past, the original Banking Act of 1864, 29 pages, Federal Reserve Act of 1913, 32 pages, and this, by the way, was a particularly sophisticated piece of legislation in which there were several major visions by factions within the Congress coming together on a unified approach. Glass-Steagall Act during the New Deal, 37 pages. Now we are in the hundreds and hundreds. And a result of this lack of democratic accountability, no one knows what is in the bill except for the lobbyists and professionals who are following this as a full-time matter. According to the recent issue of The Economist magazine, the leading financial industry trade association deployed 5,490 people to work with the various subcommittees connected with the Dodd-Frank legislation. They are awake, the rest of us are asleep. one particular example within Dodd-Frank, the Volcker rule. Now, Paul Volcker is frequently here at the around the Hoover Institute. I heard Paul Volcker proposing the Volcker rule before it got passed. He was able to express it in a single sentence. Basically, banks that are insured by the government should not be permitted to engage in proprietary trading because their losses would be paid for by the public. Expressing that sentence in the Dodd-Frank statute took them 11 pages. The proposed regulations to carry out that single idea have come to 298 pages. And this is to be implemented through a questionnaire to be sent out to the affected firms that have 383 questions, 1,420 sub-questions. A banker who is a supporter of the Dodd-Frank bill and of the Volcker rule in it described this as unintelligible any way you read it. Now, unintelligibility has a lot of problems, but one of them is serious lack of democratic accountability. Why do we bother to elect people of our own choice to Congress if the laws are so voluminous and so incomprehensible that they cannot be read? Second problem is the opportunities for corruption and the unequal opportunities that are created by this kind of a regulatory system. So back to Jimmy Madison again. Another effect, he wrote in Federalist 62, is the unreasonable advantage it gives to the sagacious, the enterprising, and the moneyed few over the industrious and uninformed mass of the people. Every new regulation concerning commerce or revenue, he wrote, presents a new harvest to those who watch the change and can trace its consequences. This is a state of things in which it may be said with some truth that laws are made for the few, not for the many. Point here being that each of these complications, uncertainties, opportunities for influence give an opportunity for some people to gain an advantage in the regulatory world over their competitors. Who has the advantage? Well, lobbyists and lawyers. Probably good news for many of us in this room that the laws are written this way. Especially large firms. And this is an important point because very frequently what appears to be regulation of business actually works to the advantage of the larger players within the industry who are better able to absorb the deadweight loss, the deadweight cost, and to the disadvantage of their upstart competitors. So whenever you read that some great large corporation is self-sacrificedly supporting some form of regulation, and then people say, oh, how wonderfully public-spirited it is of them to be supporting this, I suggest that you take a jaundiced view and ask yourself the question, is this going to hurt their competitors more than it hurts them? The revolving door, the bureaucrats, the agency lawyers and officials who work for the agency one day or for the congressional committees one day and go out and work for the regulated firms the next day. This is a very tight a tight network, which I don't think we should assume is necessarily acting in the public interest. And of course, the power of political connections, right? Because at every stage, when firms or individuals need to get regulatory permission, they have to go and kiss the ring of the folks in Washington. They have to flatter, they have to support. You want to make sure that your lobbyists have contributed to the proper campaign. All they have to do now is Google, and you can find out exactly to whom they have contributed. I have a friend who owns a small business. He and his brother are partners. He likes to give money, not in large sums, hundreds of dollars to various candidates that he believes in. for philosophical reasons. He was telling me that his brother was pleading with him to stop doing that because he's convinced that when they go to their regulators that it works to their disadvantage to know that they've been making political contributions to the wrong folks.
Judge, I'm going to have to limit you kind of time-wise. So.
Am I up, or can I? I'll quickly finish.
Okay. Do we have point 3?
Yes.
Is it short?
Well, it can be made short.
All right, please.
The effect on prosperity, back to Jim Madison. What prudent merchant will hazard his fortunes in any new branch of commerce when he knows not, but that his plans may be rendered unlawful before they become executed, before they can be executed? What farmer or manufacturer will lay himself out for the encouragement given to any particular cultivation or establishment when he can have no assurance that his preparatory labors and advances will not render him a victim to an inconstant government? This is the danger of uncertainty. And if you speak to business people today, you will find that one of the leading complaints that they have, one of the leading reasons why they are not hiring and expanding, is not just the extent of regulation, but the uncertainty of regulation, because they do not know what's going to be happening to them. They do not know whether they're going to be able to reap the rewards of their investments tomorrow. So my suggestion is, let us heed the words of James Madison back in Federalist 62 and try to return to a world of regulation which is based upon predictable rules rather than upon case-by-case discretion. Thank you, Judge Haight.
Thank you, Judge. Professor Engstrom.
All right, so thank you to the Federalist Society for inviting me to take part in this and for putting on this event. It's a little crazy for me to be batting cleanup, I think, as the junior member of the panel, but here's why you should listen to me. What I lack in scholarly wisdom, I make up for with no substantive experience in any branch of government. So I do have some things to say, and I want to use my limited time to focus on the idea of regulatory capture. It's something that's come up quite a bit in various of the presentations to this point. And so I want to try to use a slightly deeper dive into the idea of regulatory capture to weave together some themes that have been laid out to this point. But mostly I want to try to make a plea for more rigor in how we think and talk about the idea of regulatory capture. And I'm going to do that by making what I hope are 3 fairly simple framing points. The first is that when we talk or think about regulatory capture, definitions really matter. Okay? When I read scholarly debates or public debates about capture, it's sort of hard to know what certain commentators mean by it anymore. There's a standard 20,000 feet definition of capture, right? It's a process by which policy is directed away from the public interest and toward the interests of regulated industry. Now, there's an obvious problem here, right? This requires some sort of a notion of what the public interest is in the first place, right? Which is a difficult counterfactual inquiry when you're actually looking at any particular policy-making episode. But it's also quite vague. And the problem here is that once we try to put more meat on the issue, I think things get even more complex. And it's really easy to lose focus. So for instance, political scientists now talk about 2 different kinds of capture. Right? They talk about materialist versus non-materialist capture. Right? The materialist version of capture is kind of the classic version, right? It's that concentrated and diffuse costs and benefits create asymmetric stakes when making regulation. Collective action problems make it harder for some groups to organize than others. Right? So it's a structural problem. Now compare that to the new non-materialist theories of capture, right? This is sometimes referred to as cognitive or cultural capture, right? It's this idea that it's capture by way of creeping colonization of ideas, right? It's industry can somehow convince regulators to think like them, right? So think about financial deregulation, which some people at least think has contributed pretty substantially to our recent economic woes, right? Lower capital requirements, allowing banks to get into the securities business, right? This came about through some sort of cognitive capture. It was industry convincing regulators that what's good for Wall Street is good for America. Now, what's the problem with the materialist version of capture? Well, if you look hard at the political science literature, it's really hard to find any good, solid empirical evidence that it exists, right? Diffuse interests actually do quite well a lot of the time, thank you very much. What's the problem with the non-materialist account of capture? Well, it starts to look a lot like the marketplace of ideas, and some ideas win out and some don't. It also helps underscore the problem that virtually any policy position can be framed in public interest terms. This goes back to this idea that it's really hard to define what the public interest is. So political scientists also talk about weak and strong forms of capture, right? And I think that's a really important distinction as well. Right, strong capture is this idea that there's so much rent seeking out there that we might actually be better off with no regulation at all. Right? Weak theories of capture says, maybe the regulation that sort of is kicked out the back end of the regulatory process is less public interested than we would like. Now, if we're talking about strong forms of capture, right, we might want to revive a really strong form of the non-delegation doctrine within administrative law, right? We might even want to get rid of entire departments of agencies, right? If, like Rick Perry, we can actually remember what they are. But if we're only talking about weak capture, then the conversation looks very different, right? Then we're talking about tweaks to institutional structures, maybe trying to design better agencies, quibbles about doctrinal structures for judicial review. And the basic point in all this, I guess, is that definitions are really good. I think it's really good that people are trying to do this because it makes us be more precise about the mechanisms that might underlie capture theories and also the ultimate harms that capture supposedly causes. Right, so that's the first point. The second point is that capture is actually highly contextual. Right? The policy area matters and the administrative instrument matters a lot. Right? The first one of these is a simple point, right? Environmental regulation is very different from insurance regulation, which is very different from drug regulation. Right? These different policy areas, they vary in the interest group environment, they vary in the complexity of the issues, they vary in the extent to which there are information asymmetries. Administrative instrument also matters a lot when we think about or talk about capture. Right? Arguably, rulemaking, which is something that I think most of the panelists have focused on to this point, is far more protected from capture or capture concerns than other types of administrative action. And that's not just for some of the reasons that Professor Heinzerling mentioned, right, congressional oversight. It's also that there's something called the Administrative Procedure Act that imposes all sorts of onerous procedural requirements and arguably brings a great deal of transparency to the rulemaking process. In my view, we should be more worried about capture as we move to more micro-level agency decision-making, right? We might be more worried about capture in the context of adjudication, where you have binary disputes, where the APA is a little less onerous in its requirements. And we should be most concerned about capture in the context of enforcement. So one of the scholarly projects I'm working on right now is trying to understand DOJ oversight of key TAM litigation. And there, DOJ makes lots of micro-level decisions that are largely hidden from view. And what I'm amazed is, I've built the world's first data set of key TAM litigation, and until now, even congressional overseers had nothing like a synoptic view of what's going on within this regime. But the point is, context really matters here, and it makes it really hard to generalize when we talk about capture. All right, point number 3. Institutional context matters, but probably less than you think. Right? When we talk about capture, we quickly get moved into a comparative institutional posture. And the basic question that we have to ask is, if we think agencies are captured, then what's the alternative? Right? One option is we can have Congress make more detailed laws. Right? Congress is, after all, making a basic make or buy decision when it decides to delegate to an agency in the first place. But we also have to ask, are congressional subcommittees, are they likely, then these are the committees that actually write the bills, are they any less susceptible to patterns of political influence? Are they any more likely to reflect the median voter, right, or the public interest? There's a reason why there are more Iowans on agriculture committees. We could also give broad interpretive lawmaking authority to courts, right? So think about antitrust law, think about Title VII. But here we know that, right, repeat players, the haves, often come out ahead in those situations, right? They have greater resources, they have a greater ability to play for rules, right, to treat litigation strategically. And so the basic point here is the one that I hammer home with my students in seminar, and that is when it comes to the structural problems that supposedly underlie capture, right, collective action problems, patterns of diffuse and concentrated costs and benefits, institutions, courts, agencies, legislatures, tend to move together. All right, how do I sum all this up? I think the best book on this topic is a book by Jerry Mashaw. He's a Yale law professor. It's called Chaos, Greed, and Governance. If you haven't read it, I encourage you to. Jerry was also one of my PhD dissertation supervisors way back when. The book opens by citing Pablo Picasso, of all people, who, in commenting on his cubist portrait, right, very strange cubist portrait of Gertrude Stein, said the following: "Everybody thinks she is not at all like her picture, but never mind. In the end, she will manage to look just like it." The basic point here is that images and perceptions are powerful, right? The is and the ought are connected. Ideas can become self-fulfilling prophecies. And so applied to administrative law and some of the topics encompassed within this panel inquiry today, right? We hear again and again that the administrative state is bad, that too much policy gets made by a runaway or capture bureaucracy. But this has a big effect. It ultimately degrades our faith in government. It undermines civic trust. Now, from the perspective of a conservative activist, that might be a good thing, right? Part of the strategy, right, is to starve the beast of resources. And yet, I want to suggest that the image of regulation that has been created in recent decades is deeply flawed. It's not sufficiently rigorous in defining terms, such as what we mean by capture in the first place. It's not sufficiently attuned to differences across policy areas. It takes too little account of differences in the administrative instrument that's being used in any particular situation. And I think it overemphasizes differences in institutions. So that's my very junior and high-level view, and I look forward to some discussion to follow.
All right, thank you very much, Professor. Now we have approximately 15 minutes for our panelists to rebut, to respond to each other. Perhaps I'll start with you. Mr. Gray, do you wish to respond to any of the panelists here?
This has been very civilized. I love it. Just three quick points. I just want to emphasize my appreciation for Professor McConnell's reference to uncertainty being, the enemy of investment and expected return, and how a drag on not only on democratic values but the economy. It's interesting, though, and maybe you can respond, Mike, but in researching this sort of very lazily, there's not a whole lot of scholarly literature about the relationship of uncertainty and investment in terms of the regulatory climate. I wish there were more. Maybe I'm just missing it. Something just to throw out. I wanted to close the loop which on something I said about capture, which echoes, I think, that I wanted to echo what Mike McConnell said. To me, the problem with capture is the revolving door. It's what happens in an agency with the people who hope to get jobs, not worked out in advance, of course, that would be criminal, but they hope to get jobs with a particular industry or interest group, and so they favor that interest group as they are on their way out or preparing their way out. And I think you're going to hear a lot more from a person who is very unpopular named Jack Abramoff, who is beginning to make this point now very forcefully in Washington now that he's out of jail, because he was the high practitioner of the revolving door. And if you look at the Wall Street bailouts and you look at the AIG bailout, if you look, it's just, I think, a serious problem. Finally, I don't think the non-delegation doctrine is dead completely. Justice Scalia did rewrite slightly the Clean Air Act statute in interpreting what requisite meant based on something that the Solicitor General said on oral argument, quoting actually in the opinion from the oral argument, saying it's got to be, sufficient but no more than necessary. Now, one of the big disappointments in my life was seeing the ozone rule get pulled by the White House, because that would have made such a beautiful test, because EPA's estimates of the benefits for the lower end, they admitted by their own terms, were highly speculative. I just repeat that, highly speculative. And so I would challenge people, Lisa, how can you say that something that's highly speculative is also necessary?
You want to respond, Professor?
Yeah, I wanted to respond to something else, and then I'll respond to that. I wanted to respond to Professor McConnell first on uncertainty. I agree. I do think that sometimes the kind of uncertainty that regulated industries don't like is the they like the certainty of no regulation. Let me put it that way. So in many cases, there are regulations that we know are coming. The statutes have been on the books. The statutes are, as I mentioned before, prescriptive with deadlines, with quite strict requirements. And so you'd think regulated industry would at some point say, a law has been passed, and let us see what we can do to affect the process relating to the rules that will implement that law. But perhaps let's recognize that we will be regulated in this respect. And, but that's not what they do. And instead, there are challenges to every rule, challenges based on quite minute readings of the administrative record, as I said. And so at the end of the day, it feels like the uncertainty is generated as much by the regulated industry that's complaining about uncertainty as by anything that the agencies are doing. On the non-delegation, I don't agree that the Supreme Court rewrote the statute. I was involved in that case as well, writing briefs in the case in which the Supreme Court held that the Clean Air Act's ambient air quality program does not allow EPA to consider costs in setting the ambient air quality standards. And I was involved in those preparations for that oral argument. It struck me that that was simply a definition of what requisite means. And the Clean Air Act also always, for all time, has been a statute that aims at preventing harms before they occur. If you're going to do that, if you're going to try to aim at preventing harms before they occur, not allowing widespread harm to happen, then you're going to be, in some cases, maybe in most cases, in a realm of uncertainty. It doesn't strike me as at all beyond the statute. It strikes me actually as at its core.
Okay. Judge McConnell.
So on uncertainty, of course Lisa's right that regulated entities, like bureaucrats, prefer to be unbound rather than bound. But that's not, I think, the main point. The point is what kind of regulation that they're subject to. And here I want to strongly agree with something that David Engstrom said, which is that rulemaking is the most transparent and the least problematic aspect of administrative law. It is when you get into case-by-case decision-making that things become truly unpredictable and not impartial. And here it's the growth of government by waiver, discussed in the panel last night, but also what I like to call mother may I type regulation, where instead of prescribing rules and then having people just figure out whether you've complied with those rules, you have to simply go to the bureaucrats in advance and get permission for what you're going to do, a standardless licensing sort of scheme. These two forms of regulation are becoming far too prevalent in Washington, and they are the ones that create truly corrosive uncertainty as well as opportunity for the politically well plugged in to take advantage of their circumstances.
Professor Engstrom?
Sure. Well, so let me try to provide some frame for thinking about this again. I think on the uncertainty point, there are lots of different reasons why there might be uncertainty at the legislative stage or at the regulatory stage, right? So if you have a vague statute, right, that gives way too much discretion to an agency, right? Congress may have done so for a bunch of reasons. One is Congress may have just punted, right? This would be consistent with kind of the rational choice theory of Congress, right? The rational legislature simply wants to take positions and avoid blame wherever possible, right? So that's one reason why you might have a very open-ended, open-textured statute, right? It might be that you needed that ambiguity, you needed that vagueness to get over the finish line legislatively, right? In order to strike the legislative bargain, in order to enact anything, you had to leave some gaps in the law. And third, there might be that gap in the law because of basic cognitive uncertainty, right? So, you have difficult policy areas, very complex policy areas, and it may just be that it's unclear at the time of enactment, right, what precisely should be done by way of regulation on any particular issue. And so one of the strongest arguments in favor of delegation is this idea that agencies can engage in context-sensitive implementation of very complicated policies. And so, again, when we talk about uncertainty, we have to think about why that uncertainty exists, why that uncertainty gets handed off to the agencies, and why the agencies are then asked to fill those gaps in the first place. We can debate, which, the relative amount of ambiguity that fits in any of those three bins. We probably can't ever prove it empirically. But I think it is important to keep in mind when we think about uncertainty and the effect that it might have on the business community.
All right. All right, now it's time to get questions from any of you. I'm asking you, please, no speeches, true questions. Anybody have any questions they wish to ask of the panel today? Yes?
I'll also just note that there is a mic up on the balcony for the 24 who figured out how to get up there.
There is? How can you see it in the light?
It's at the left over there.
So I'm Bill Evers. I'm at the Hoover Institution. And I'd like to ask Michael McConnell sort of the same question I asked David Barron last night, but I would add that in your slide that whipped by up there, I saw No Child Left Behind, and I've seen in the Wall Street Journal that you've mentioned concern about national standards and national curriculum. And so I wonder if you could tell us what you were not able to tell us when your slides whipped by, and what your thoughts are on the waivers and the charming things that the U.S. Department of Education is up to, and even its deep love of statutory prohibitions on against what it has been doing.
Well, what Mr. Evers is referring to is that No Child Left Behind was a quite prescriptive and rather inflexible statute that allowed the Department of Education to issue waivers against the deadlines, because the deadlines are very difficult to meet. One might think that waiver authority is designed for those, if you can show that for some particular reason you're delayed in, maybe you have a particularly, your demographics or whatever are such that it's particularly hard to meet that, or you have put into place a program that's going to take place over time or whatever, but where the waiver would be related to the inability to meet the deadline for some reason. But instead of that, the administration has adopted a policy. Now, over half of the states have applied for waivers, and the administration has adopted a policy where they simply put aside the statutory requirements and grant a waiver if the state agrees to a set of policies which are nowhere reflected in the statute and that are entirely administratively corrected. Now, I'd like to comment, I don't know if Mr. Evers and I would agree on this. I actually agree with much of the policy behind the administration's ideas. This is a democratic accountability point, not an educational policy point. But through the waiver process, we have seen a creation of an alternative regulatory regime that is quite contrary to the one that Congress had enacted. And I find that a quite troubling development.
All right, let me go to the microphone on this side.
Thank you. My question is for Professor Heinzerling, and regarding your comment about regulated entities creating a lot of their own uncertainty as they enter into the rulemaking process and challenge each rulemaking effort. I wanted to ask you a historical question regarding environmental regulation. And your colleague at Georgetown, Richard Lazarus, wrote his history of environmental law, in which he argued that the reason that environmental lawmaking stabilized, in a sense, in the 1980s and remained impermeable to efforts to kind of cut it back was because the regulated entities wanted the stability. They wanted the regulations that were already in place to stay there and not change. So I was just wondering, do you agree with that assessment? And if so, do you see that changing now with regulated entities being more resistant to rulemaking, or do they just want to keep status quo?
I think that there may have been some of that in the 80s. I think, and if so, that has certainly changed. What I can say with some confidence is I don't see that same dynamic today. It seems as though every administration, every rule is up for grabs. There's a kind of perpetual dissent that occurs. Even, like I say, with statutes that have been on the books, you can see these rules coming for decades, literally for decades, in industries that are otherwise knowledgeable, savvy, try to get ahead of things. And so it's striking to me that they don't look at those statutes, see how prescriptive they are, see this coming, and plan for it, and at some point get on board. And as I say, try to make the rule as maybe comfortable as possible for them, as sound as possible. But what I see today is constant second guessing and kind of relitigating, if you will, of those basic provisions.
Okay, thank you. Yes, do you have a question?
Yes, this question's mainly regarding the regulatory vagueness and uncertainty that Judge McConnell first spoke about. And forgive me if this shows through some ignorance. I don't have much experience in this area, but I was wondering if you could comment on a number of regulatory requirements now carry criminal punishments. And I was wondering how you could, if you could speak on how the lack of a lot of mens rea requirements in these regulations bear upon that uncertainty, and even whether we think it's proper that these agencies should be able to promulgate regulations that are basically strict liability.
That's an excellent question. I do think that the criminalization of a lot of the regulatory field has been an unfortunate development. Sarbanes-Oxley is an example of where where it becomes very difficult for a person even acting in good faith to be able to operate. And I do think that in general, willfulness requirements are, there's a reason why the common law of crime developed mens rea requirements, because they do prevent traps for the unwary. So I would second the sentiment of that question.
All right, here, sir.
Hi, I'm Phil Albert. I'm from Duke Law. Mr. Grassley, you went to UNC. Go Duke. Big basketball game today.
Are you speaking about tonight?
Yes, sir.
Oh.
And then Judge McConnell, I was wondering if you could speak a little bit to solutions that we have. How do we fix this problem of 2,000-page bills where we have to pass them to learn what's in them?
There's obviously no silver bullet, because this isn't just a mistake. This is a whole way. This is a whole culture of politics and regulation. I think it needs. We need, first of all, there needs to be an intellectual change. We need a new James Landis. His name was bandied about quite a lot on the panel last night, but we need an intellectual vision of how a regulatory state can return to a more rule-based approach. We need a new political movement, and in this respect, I find, although, I'm sort of the opposite of a populist, but I find, not only do I find the Tea Party an uplifting and encouraging development, but I'm even have some sympathies with the Occupy folks, because what they both have in common is a realization that politics in Washington is not working very well for the ordinary people, and if our members of Congress could be inspired to pass legislation in a different way, I think that would be helpful. I think it is time for a thoroughgoing revision in the rules of parliamentary procedure that govern Congress, because we have a vicious combination of impossibility to pass legislation, but also lack of transparency. We've set up committee systems which are almost guaranteed to not to reflect the median voter, but rather the most interested parties. I think our congressional procedure is quite bad, and I'm not an expert in the Administrative Procedure Act, and I'd love to know more about what David might say about this. But it seems to me the Administrative Procedure Act is no longer describes the world of regulation that we are in, and we need some sort of framework for judicial review which does not allow the most pernicious forms of case-by-case arbitrary regulatory activity to escape review as it now does. So those are just a few thoughts.
How about that, Professor Engstrom? Anything you want to say there?
I'm not sure how to respond to that. Good luck revising the Administrative Procedures Act in this political climate. It seems like gridlock pretty much rules the day, and that would be a massive tectonic shift. And as we know, like big ticket legislation is very hard to move through Congress. It just seems like I appreciate the call for that sort of a move, but I don't see it coming down the pike anytime soon. Maybe Professor Heinzerling has a different view.
Well, I'm not sure that I see it coming down the pike, but I agree with it. I agree it needs revisiting. The thing, you read the Administrative Procedure Act, if you were from another planet and you read it, you would imagine an administrative state that is utterly unlike the one that we have. And it strikes me that it should be updated, revised, completely refurbished to reflect the reality of the modern administrative state and to take away some of these procedural requirements that have become, in my view, too onerous.
Yes.
Just a little sort of dissent to procedural requirements. It's too complicated to go into in great detail here, but the grand bargain which I referred to, where the automobile companies and California and the federal government all agreed to do what is now being spelled out, involved a secret, a set of meetings at the White House as to which there was a blackout. I mean, I think it was said publicly, we will not talk about this publicly. We will not let anyone know what happened behind these closed doors. This is all sort of rigging the rulemaking that was later to be proposed way in advance and in secret. And part of the bargain was, as I said, that none of the participants would seek judicial review of the ultimate outcome. So you had a marvelous sort of little package done in secret, which included appellate review. And I don't know what you do about that. If that becomes a pattern that happens more and more and more, we really have eviscerated, and I don't know what procedural rules will fix that, but it's certainly not, to me, a very comfortable way to reconcile the Administrative Procedure Act with the way an entire industry's 30-year future has been decided.
I just want to add one point. That's not true. Guess I'll stop there.
Which part?
The auto industry did not agree not to challenge the final rule. The deal was that the agencies would propose a rule along the lines of the discussions with all of the stakeholders, but there was not an agreement that they would not challenge it. They like the rule.
All right, the gentleman here.
Yeah, my question is for Professor Heinzerling. Specifically challenging the notion of democratic accountability in an ever-expanding federal government. We know that post-Pendleton Act, actually only less than 10% of the federal government are actual appointees. The real concern is the 90% plus that are career civil service that essentially can't be fired. Max Weber, in his treatise on bureaucracy, stated, "The political master finds himself in the position of dilettante who stands opposite the expert facing the trained official who stands within the management of administration." Thus, the problem really isn't so much corruption, but it's more structural. Essentially, that we have a discretionary over-specialization in government bureaucracy, for lack of a better word, sophisticated ignorance. And how would you respond to this criticism?
Nicely done. I think you have a point. I think you have a point. There is, in many agencies, there is a little tiny, it's even worse than you say. In some agencies, there are 2 appointees sitting atop a vast bureaucracy. I would say that in many cases, that vast bureaucracy is very expert, very technocratic, not unsophisticated. So I would disagree with that part of what you're suggesting, but I agree with you. It's very hard to get a handle on a bureaucracy that vast. What I was suggesting is I think we have, in many respects, at least the largest outputs of the regulatory bureaucracy are vetted very closely by political appointees. I think that Professor McConnell has a point that some of the things that are the least vetted are the individual case-by-case judgments, and those are hard to get a handle on. I agree with you.
Yes, sir.
Thank you. I'm Peter Shane. Just to follow up on Professor Heinzerling's point about uncertainty, I'm wondering whether the world from that point of view would not be better if the courts cut back on pre-enforcement judicial challenges to rulemaking. That is, I mean, right now, one of the reasons for prolonged uncertainty is that an industry may make the calculation that, 3 years further delay through litigation is preferable to actually doing what you suggested, which is influencing and then accommodating to the rule.
I think this is a wonderful question. It's one I've thought a little bit about, but not enough to have anything to say that's truly sensible or wise. But I have wondered the same thing as whether pre-enforcement review has created a kind of cottage industry of regulatory challenges, regulatory uncertainty that may not exist. It may be that if you didn't have that review, that by the time people were faced an enforcement action, they may have become comfortable with the regulatory regime. I'll just add one example. We see not only pre-enforcement review, but the other day Shell filed a lawsuit against environmental groups that just might, challenge a permit for oil drilling in the Arctic Sea. They filed a declaratory judgment action in an Alaska court saying that our permit will be legal if it's granted, so that to avoid the judicial review of the permit. So we not only have pre-enforcement review, but if that succeeds, we have pre-enforcement review, which makes things even worse.
You have something on that.
But on the other hand, if the regulation requires massive investment and change in industry practices, and it's then enforced for several years before it can ever be challenged, all the damage will have been done.
All right, next.
Good morning. My name is Richard Sala. I'm from Vermont Law School. This question is for Professor Heinzerling, and it's a similar strain. But the panel returned several times to the problem that Congress is as susceptible as agencies to corruption and to capture. But I wonder if the level of susceptibility can answer the question of the people's right, or if it abates the people's right to accountability. And so when you were mentioning renaming the conference, I wonder if a better name would not be Agencies Accountability Bound.
I'm trying to understand just a little bit what you're getting at.
Just, we mentioned several times that about the restrictions that there are on agencies, but there's still a perceived lack of accountability. And so it seems that that the agencies themselves being unaccountable, that is more bound than the restrictions themselves.
Okay, it's complicated. What you're saying is complicated. I think I get it, and there is a strange way in which some of these mechanisms of binding, restraining the agencies, making sure they don't do too much, trying to delay them and so forth, make them in a way less accountable. We'll give you one example, that some of the restrictions that lead to delay and so forth mean that the agencies just don't do the work that Congress has assigned them. They just don't do it. If they don't have a deadline suit, for example, they do not do the work. That strikes me as less accountable rather than more accountable.
Yes.
Hi, thank you. My name is Tyler Ward. I'm also from Vermont Law School. My question is for Professor McConnell. How do you see the Negotiated Rulemaking Act fitting into this? And do you believe that rulemaking in this manner by agencies is better structurally, practically, or any of the other panelists?
I have to admit I have no experience with negotiated rulemaking and don't know.
Yes?
We did a lot
someone else here does.
Well, I've sort of forgotten it, but because nothing's really happened with it. But recently, but it became a fairly big deal with the administrative conference back in the early '90s, especially in connection with the implementation of the Clean Air Act. And there were 2 or 3 key provisions that were negotiated out by the parties as part of the rulemaking process, done pursuant to obviously disclosure requirements, and they were highly successful. I mean, you know, the Title IV acid rain provision went in to effect without any judicial review whatsoever. No one ever challenged it. It went in, and it was an enormous success without a hitch. Reformulated gasoline, which is a huge boon out here in California, the first year RFG went into effect, ozone exceedances dropped 40% or something, again, done by negotiation between the oil companies prior to the proposal of a rule. Highly successful. Why it's gotten dropped, I don't know. And maybe it ought to be revived, because it is a way of cutting through a lot of the delay that Lisa's complaining about, and the hassle from the Congress, and, you know, the uncertainty of will someone appeal, will someone not appeal, what's the standard. I think it was a great innovation. It just got lost, and I can't tell you why.
All right.
Hi, Jeff Lynch from Georgetown. My question is for Mr. McConnell. With respect to Dodd-Frank and the Volcker Rule, I think that one of the reasons that you have such a lengthy and vague rule is precisely what David mentioned, is his third bin of cognitive uncertainty. And I think that how we define proprietary trading in light of the hedging and market-making exemptions is a question that it's largely theoretical, because we don't know how it's going to play out both in our domestic and international markets. And so my question is, how do we expect Congress to be able to make concrete judgments about the effect of, for example, the Volcker Rule, without allowing the agencies to really experiment with, different proposals, and to figure out how market forces will respond to them?
I'm not sure that this is a Congress versus agency issue, because if it's a cognitive problem and we do not know, if economists cannot tell us what proprietary trading is, if we don't know what it is, then maybe we shouldn't be regulating on that basis. That I think of Wittgenstein's statement, whereof we cannot speak, thereof we must be silent.
Well, I think we have a general sense of what it is. I mean, it's not as clear cut as Glass-Steagall, but
Well, you got his answer. Anybody else have anything? Nobody else wants to talk?
Well, it's really it's really a puzzle, isn't it, Mike? I mean, to take something as, Glass-Steagall was only 30 or 40 pages, or 20 or 30 pages, I don't know how many pages it was, and it seemed to work fine. And now it takes 3,000 questions in order to even replicate a part of it. So it's a really real metastasis of some sort of dysfunctionality, which I don't myself fully understand.
All right, for our next question, I have a little conundrum here. We have Judge Bea from the Ninth Court, Ninth Circuit here, our hero, and we have the former Secretary of Energy, John Arrington. Let's see, who's higher in stature?
Obviously, Judge Bea.
Oh, thank you. That's very gracious of you, Secretary Arrington.
Don't we have a professor to ask a question?
All right, Judge Bea.
I'm Carlos Bea from the Ninth Circuit, and I hope you won't hold that against me. I'd like to focus your attention on the Chevron rule, which we get every day as appellate judges. And I was thinking about the basis of administrative delegation, which was explained yesterday, I think very well by the panel, as based on the Landis rule that experts seem to know more about this because they're in it every day, and therefore, if the statute is somewhat ambiguous, we should let people who know more about it interpret the statute for us. I wonder if that idea has become somewhat naive in view of our discussion of the capture problem, in view of the idea that the bureaucracy has a life and interest of its own, perhaps quite far away from congressional intent. The question is, should we re-examine the Chevron doctrine and perhaps return interpretation of the law to the judges?
Who would like to do that?
Let me just give, my sense is that Chevron is honored in the breach, or whatever the expression is. It's breached more often than it's followed, and there have been studies about Supreme Court jurisprudence about Chevron and how often they make exceptions to it. I'm not sure it actually really applies anymore. It's used whenever it's convenient, and it's ignored when it's not. But I agree with you, the premise of your question, we shouldn't be so deferential, and I think you see, and heard this yesterday a little bit, the D.C. Circuit getting a little more feisty about this. And there are arguments as to whether you should codify a cost-benefit analysis requirement. Lots of objections, and some of them from the academic community on the grounds that it's only going to gum up even more the regulatory process and delay things even further and overburden the courts. And I'm afraid to say I know there are two D.C. Circuit judges here, but the D.C. Circuit workload is not overwhelming, and they can handle this. Believe me, they can handle this and might want to handle it. I don't know. I don't speak for them.
Anybody else wish to respond to that?
Well, I do not think the proper ground for Chevron is expertise. If it's a proper doctrine, it's because Congress has delegated to the agencies the authority to interpret the words of the statute. And in this respect, I think it's important to distinguish between two different kinds of statutory interpretation. One has to do with the extent of the agency's authority, and as to that, I do not think we should have Chevron or any other kind of deference. If anything, I think we ought to have some kind of strict construction that agencies should exercise no more power than Congress has actually delegated to them. But with respect to the interpretation of the powers that they do have and how those are going to be exercised, it does seem to me that the agencies are the proper congressionally delegated agents to make those decisions, and that for the courts to tell them no, you really should have regulated in a different way is generally to be avoided.
Secretary Harrington. Oh, sorry. Did you wish to respond? Secretary Harrington, you know a little something about agencies?
I do. We had 27 oversight committees. I spent all my time testifying. Two short questions. I'm going to direct the first one at David. David, I liked your presentation a lot, but I was troubled by my impression that you thought everything was pretty good. We need to tinker around the edges. We need to change some terms, define what we call things. is somewhere in your position, do you recognize that there are people in this audience that want to buy their own light bulb, found a toilet that flushes with more than 1 gallon, make educational choices for their children on a local level? Is there room in your presentation for that? The second is a little shorter. I didn't hear one of you up in that panel address what I think is one of the most dangerous things that's happening today, and that is a White House czar who is not confirmed by the Senate, who is setting regulatory policy. And there are cabinet officers, I know this for a fact, in this administration that are reporting to the czars instead of the President of the United States. Dangerous and bad. Would somebody comment on that?
All right, Professor Engstrom, you want to talk about the toilets and the whatever else?
Happy to talk about the
and the
toilets.
children's lunches or whatever they can do.
Sure. It's hard to different. I guess I'm having a little trouble understanding whether your concern is about creeping regulation of all aspects of social and economic life, or whether your concern is that it's agencies that are somehow doing that. I think it just begs the question about, why Congress is delegating, policy-making duties, responsibilities to agencies in the first place. That may be the problem. This may mean we need, again, some kind of a big tectonic change. Maybe we need a new APA that governs all of this. Maybe we need a political movement that asks why, we would bother regulating the way toilets flush. But, it's just not clear to me that the specific problem here is delegation. It's a tricky set of questions. Delegation obviously clearly allows Congress to abdicate its responsibility to some extent, and yet it plays this incredibly important technocratic role in allowing for context-sensitive implementation of regulation. And it's just not clear to me how we define the problem. If we define it quite narrowly in terms of capture, I think there actually isn't that much of a problem. I don't think that empirical evidence on political science, for instance, suggests that there's a strong problem with respect to capture. And if we define the problem really broadly, then I think we're talking about a political system that has, in recent decades, regulated more and more aspects of social and economic life. And we can talk about whether that's welfare increasing or welfare reducing. But again, I don't think it's a problem of the administrative state then.
And also the question about the democratic process.
As to czars, that they belong to the next panel.
Yeah, I think they do. But there is.
You'll hear lots about them, I think.
It's that the title of our panel sure peaked that, though, I must say, the democratic process, and are we undermining it? Let's see. I went there. Okay, you.
Okay, I'm Cody Smith. I'm from the University of Texas Law School, and I think Professors Engstrom and McConnell would probably be best suited to answer this, but anybody who could speak to it, I'd be happy to hear from, obviously.
Yeah, Lou.
Okay. Better? Okay. UT Law School. Professors Engstrom and McConnell would probably be best suited to answer this question, but my question is that if we assume bureaucrats are subject to capture at the enforcement level, at like the initial oversight level, is there any way to like measure or observe or just like to observe that and to maybe fight that if that's actually happening? Is there any way to observe the like initial like basically failure to enforce as sort of regulations?
Well, David's more the empirical person, but I would think, I've seen studies of little pieces of highly discretionary case-by-case decision-making in which you can see patterns of that show that there's no consistency and thus the same rule is not being applied across the board. I think, for example, there's one excellent study of at the district judge level of exercise of sentencing discretion after the Booker decision. You can actually look online and see what the rates are of decision-making of immigration judges in highly case-by-case matters. Now, if we assume that the numbers there are large enough that it creates a kind of randomness, and I don't know enough about the data set to be sure that that's so, it suggests that we do not have a rule of law in some of these areas, and that's concerning to me.
Did you have anything you wanted to add?
Well, I do think that this is a really important new development in legal scholarship, right? This is part of the empirical legal studies a movement, and I think there are more and better studies that look at these enforcement questions. So I think SEC enforcement decisions are being subject to more and more scrutiny. The question of whether to proceed against regulatory targets in-house versus by way of civil action in federal court. Really interesting stuff on that. I'd like to think I'm contributing to this literature a little bit. I've built this data set of key TAM litigation. It's this exploding area of litigation. It's incredibly important. It's $3 billion a year, which makes it as big as securities and antitrust. And DOJ exerts all kinds of control over that regime through its ability to intervene in these cases. So hopefully when those articles come out, that will help push the ball forward even further. But of course, the problem with enforcement regimes is they're decentralized and they're hard to get at empirically. And that just goes to the question then of, or the issue that these things are less subject to congressional oversight. And so again, if we're worried about capture, if we're worried that patterns of political influence are distorting agency decision-making, we should probably look to micro-level decision-making context, enforcement, adjudication, not macro-level.
All right, I want to thank you all very much. Our time is up. Our panelists will be here. For the few that were standing there, maybe you can ask their questions outside. I want to thank our very excellent panel for their presentations.